launch into the debate. Just to bring you up to date, Fiona Patten is behind a bill that, if passed, will extend the Racial and Religious Tolerance Act to include gender identity, disability and sexual orientation, and will ban speech that is likely to incite hatred or likely to incite severe ridicule. Joining me in the Melbourne studios is Reason Party leader and MP Fiona Patten, and we've also got Liberal Democrats MP David Limbrick, who is not a fan of this legislation. In fact, he is vehemently opposed to the bill. But let's start with you, Fiona. Why did you bring this forward?
Yeah. Look, I think we've had a Racial and Religious Tolerance Act in Victoria for nearly 20 years. And this is to stop the most extreme abuse, vile incitement of crime and violence against people on the grounds of their race or their religion. That's been around for nearly 20 years. And my bill was to suggest that those protections should be extended to people on the grounds of their sexuality, their disability and their gender. This was done in New South Wales last year. It's been done in Tasmania, it's been done in Queensland, it's been done in the ACT.
What's happened in New South Wales and elsewhere isn't like what we've got here. New South Wales, the changes were in the criminal code, and the standards there are much higher. One, you've got the presumption of innocence. You've got it's beyond reasonable doubt.
So is mine. I mean, of course, any legislation is beyond reasonable doubt.
Not in a civil, not in a VCAT. Yeah, that's a criminal matter before the courts. And if you look at the New South Wales legislation, it's quite. Well, the bar is quite high. You've got to have an offence that publicly threatens or incites violence on grounds of race, religion, sexual orientation, gender identity or intersex or HIV status. But the offence has to be publicly threatening or inciting violence. It's not likely. It's not
that actually
severe.
That is actually the reasonable adult test. Like that.
But
so
no, there you know what you're doing. There's no grey, it's not a subjective judgment call. If you publicly threatened or incited violence, you know you've done that. It's not a
No, you were found to have done it. You don't need to know that you've done it. You are found to have done it. You are found to have broken the law. Yes, we have kept it we have kept it as a civil matter because we think it should be dealt.
But if you want to be like New South Wales, why not have it in the criminal? Because when it went through New South Wales, it went through without little controversy.
I know, which surprises me. It surprises me that everyone's...
Fiona. The bar is far lower. David?
Okay, look, I would have to say that the bar is not lower. The bar is exactly the same. And if you look at the wording, it is exactly the same. So this is why I'm so surprised by the reaction when no one reacted like this when New South Wales did.
Because it's a different thing.
In the Victorian Code, we're looking at things that incite severe ridicule or hatred, whereas in the New South Wales Code, it's incitement to violence. These are two very, very different things, which is why it's in the Civil Code in Victoria. And so actually what they've done in New South Wales, incitement to violence is actually something that I do support having criminal penalties for. And I think that's why it was pretty uncontroversial in New South Wales. But what we're looking at here, like severe ridicule is
basically, I mean, the show I do on a Sunday...
Would you have repealed the Tolerance Act? Would you have repealed... Like, do you think the Racial and Religious Tolerance Act that's been here for 20 years should be repealed?
Yes.
Right. So you don't believe that legislation... that has actually had one conviction, I might add. It's had...
But how many people has it dragged through a terrible process?
3. Yeah, but... 3 in 19 years. I actually... It wasn't intended to get rid of racism. I mean, this is not about discrimination. This is about vilification. And I think quite often people conflate the two. But discrimination is...
Severe ridicule is another bar that's in the bill.
Yeah, so. and that, as I say, that is in there. And I actually believe that in some legislation in New South Wales that's also there, as well as Tasmania, Queensland and the ACT. Severe ridicule wouldn't be a criminal... it wouldn't be against in the Crimes Act, and nor would it be, and nor is it in Victoria. But when you are...
So if you've got some ridiculous bit of activism or an activist if you can't even use mockery to challenge their point, like, do you not see that as just a step too far in inhibiting free speech and free expression? You can't even mock something that is mockable because it could likely lead to severe ridicule, and you could might end up 6 months in jail in Victoria.
I think, look, not that I've been stalking either of you, but in looking at your Twitter feeds and in looking at your social media, at no point have you ever vilified anyone. You know, you may have mocked people, you may have...
ridicule anyone either that I'm aware of.
And you know, in fact, the only case where the severe ridicule and inciting of hatred has been found in Victoria was Blair Cottrell over the Bendigo Mosque incident, and that was that. And you know, that's the bar we're talking about. So we're not talking about mockery. We're not talking about that. We're not talking about even the examples that you used in your second reading speech about someone saying, "Core, that was nearly the beep, beep, beep." This is around really vile things where people are saying you should be raped on your way back to the car park.
But that is definitely an incitement to violence, though. That's a threat of violence.
And that's already
under criminal law. That's already under criminal law.
It's very hard under criminal law, it has been very difficult. The police, when a woman goes and says, "I've had 2,000 messages of people, you know, telling me that I shouldn't be alive, that I should go and kill myself, that I'm not worthy, that, you know, all of the rest of these things that don't all add up to vilification." But when that happens, the police say, "Yes, look, not much we can do. Turn your social media off and, you know, just stay low." Now, Rita, you couldn't do that. David, you couldn't do that. And I certainly couldn't. It's our jobs.
But I can block the person. I mean, as a conservative woman, you want to see vile, misogynistic threats and abuse and just, you know, vile messages. Try being a conservative on Twitter. Conservative women. So I see it. I block very liberally. Like, if I see anything I don't like, I block.
Yeah.
And to me, you know, if something makes my skin crawl, and I see it as more than just something that's trolling, that I think there's an actual threat there, I might refer it. But then I just think, what about the unintended consequences?
Yeah.
Have you considered that? The fact that these laws could be, as well-intentioned as they may be misused to go after people who are guilty of wrong speak, who are guilty of challenging this PC groupthink.
Yeah, the bar is so high, I can't see how that could happen.
Likely to ridicule. I mean, David, you tell me how you see it.
It exists today. You cannot... You know, we've got, as I say, we've got the Racial and Religious Tolerance Act, which, can I say, there has been no conservative... there has been no conservative
because the bar is high here. It says, in Victoria, it says a person must not, on the grounds of religious belief or activity of another person or class of person, intentionally engage in conduct that the offender knows is likely to incite hatred against the other person or threaten.
That's lowering the bar under the new bill.
Well, no, all we've taken out is no, which brings it into line with New South Wales, Queensland, Victoria, and New Tasmania and the ACT.
So here they know what they've done. Under your wife, you could unwittingly be guilty of this.
It moves it from a subjective to an objective test. So this allows
I think it does the other way. I think it becomes more subjective.
How do you get inside a perpetrator's head and say they knew? Like, how can you expect a judge to do that? It's an anomaly. We're the only state in Australia that says that a judge must try and get inside the perpetrator's head to understand what they have said. Now, I guess I'm seeing the attacks that you and I might receive online, that David would receive from some time. You know, we're resilient people. This is not going to affect us. But when 1 in 5 LGBTI people is actually physically assaulted in a year, 20% of
That's already a crime. I mean.
But let's look at how that crime becomes, and we know that attitude. We know culture.
And to say that the bulk of that is transphobia or homophobia is, again, not, I don't think, accurate. If you actually look at the stats and look at partner violence and how much that accounts for those for those acts. So sometimes those stats can misrepresent.
And 30% of women receive online harassment. This is not about harassment. This is about really vile, vicious attacks that are inciting hatred, that may incite severe ridicule. And I saw some incredibly awful things said to people with disabilities.
But why is likely to incite severe ridicule? Why should that be something that's essentially unlawful? I mean, it may not be pleasant, it may not be nice, it may not be what you would do in polite society, but why should it be illegal?
Well, should the church be protected from severe ridicule? I mean, because that's what the current law is doing now. Protecting
the church?
Well, yeah, I mean, it's religious...
Look, I just think that severe ridicule is a very high bar. Like, and as I say, I mean, I would be, you know, I have been incredibly critical of the church. Absolutely.
Yeah.
I have been incredibly critical
Fiona, you
of
know how
certain
these
people.
pylons happen pylons happen online where,
yeah.
you know, someone is the target that day. So you could send out a tweet highlighting something absurd someone has said or done, or some political position they've taken, and they may get, you know, 100, 200 messages saying, my God, you're an idiot.
Yeah.
Now, you could say, well, you've opened that person up to severe ridicule. They've become the joke of the day. So you are guilty, but, you know, what you've actually done is pretty minor.
That's exactly right. And as we all know, having read the bill, that there is complete protections for reporting, there's complete protections for artistic expression. You know, this is...
That didn't help, that didn't help Bill Leak. I mean, he wasn't found guilty, but it didn't stop him being dragged through the process, which is costly.
This was that was discrimination, discrimination, not vilification.
Yeah, but it's similarly, like you said, the process is the punishment.
Again, think about how this is actually...
3 cases in 20 years.
In Victoria?
Under the Racial and Religious Tolerance Act.
That suggests it's not needed?
Effective.
I think what it suggests is it says that the standard we walk past is the standard we accept. So if we say that, no, it is not right to racially vilify people, to vilify them on the grounds of their religion, and as I say, that is a high bar. You know, I am critical of, you know, the Catholic Church, for example. I have been critical of you know, different organisations, but that being critical is not vilifying.
Okay, look, I've got to give David a go because you haven't said anything. The women have dominated. Let's have some white male privilege here, please.
Right, so the first thing is, I agree that we don't want people vilified, right? That's the question is not about that. The question is really about, is this law going to be effective? And if we think, as I said in the second reading speech, if we think about how this is really going to work, someone is going to be upset about something, they're going to go to VCAT, right? And then we're going to have a victim. And then they're not going to be able to afford lawyers or something like this. The person who's the defendant in this, they're going to go crowdfunding it, right? So that means more publicity, more pylons, and David, this goes on for months and months and months. And then you end up with this case at the end of it where it's actually everyone's discussing what's been going on, and it's made the situation far worse. And with the new abilities in this bill, which give you the ability, which give VCAT the ability to produce documents, because that's a big problem on Twitter, right? So you've got people saying nasty things about you. You don't know who they are. You don't know where they live. Are they going to come under Victorian jurisdiction? We have no idea. So they need to produce documents. So they're going to go to Twitter and ask them for all this information. They have to produce it. Are they even going to be in Victoria? I mean, how can you police this stuff that's under state law, where we're looking at something that's a global phenomena? And people will just switch to being anonymous. Like if this is widely used and people become aware of it, because let's be honest, most people outside of, you know, the political classes, they don't even know these laws exist. Like, they have no idea. And so talking as if it's some sort of deterrent, I just don't think it's
David, would you support it if this legislation or these sort of additional protected classes were introduced, like in New South Wales, under the criminal code? So it deals with criminal offences where it's the incitement to violence. Would that be something you would back?
Yeah. So from my point of view, from, you know, the classical liberal point of view, the the limits on speech are incitement to violence and threats of violence, right? So they're absolutely criminal because threats of violence are violence.
That's it.
But that's the way that the federal law works at the moment. That's the way the New South Wales law works. That's not how this proposal in Victoria
We don't
works.
have any federal vilification laws.
No, but we have threats using a carriage service, so that works under federal law.
Yeah.
If you make a threat, like a death threat or threats of violence towards someone using a carriage service, that's covered under federal law already.
Look, because I know I'm not going to win with you two here at all, so I knew that when I came in.
And we applaud you for coming in because, I wrote about this earlier in the week, so you knew where I stood.
Yes, exactly.
You were coming in with your eyes open, but you got the guts to do it, so good on you.
No, and I think, and look, I'm kind of pleased that both of you actually agree that vilification should not be allowed. But
well, I agree that threats to violence shouldn't be allowed. Severe ridicule is...
I thought I heard you say that you didn't believe that people should... It should... Oh, OK, it shouldn't be illegal, just shouldn't happen. Is that what you're saying?
Is the law effective in preventing this, or are we talking about the conduct of people?
I think law sets... I think law sets standards. I do think law sets standards, and I think if we want to live in a civil society, I think laws do enable us to set standards, and that, in my eyes, is what these laws...
You can't legislate politeness, Fiona. You can't legislate decency, and you've also got to look at the other side. What do you lose by putting this legislation in? And that freedom of expression, freedom of speech, that is a big thing to lose.
I would question what...
It's a big price.
Let's remember that this legislation has been around for 20 years in Victoria on race and religion, and no one has felt that their free speech has been stymied.
Oh, I don't know about that.
The law in Victoria... I think if you actually look at the law in New South Wales, and I know you're talking just inciting violence, the law in New South Wales is actually broader than that. I don't have it in my giant folder in front of me right now, but it is broader than that, and...
But it's only looking